spend money on that, but why does that person not have receipts to justify it? And many times people do come to court. It's not a rule, but it's possible also. And you might say, you know, I'm spending money on this and that, but you're not, to inflate the amount, which is also not correct. You will soon hear from the maintenance court where they will be giving you a date to appear back at the maintenance court for an inquiry. They would either inform you by post or subpoena. On the date, both you and the person from whom the maintenance is claimed would have to appear. If you are planning to make use of a legal representative, inform him or her earlier about the date so that he or she can be available to assist you at court. Very important, lawyers are very busy. They are not always available on the dates that you advise them to be available. I mean, like I might have been in court this morning, had you approached me a few weeks ago asking me, Advocate, are you available to appear on my behalf? Like this morning, I would have known that time already I'm not available. However, should you have contacted me maybe 2 months in advance or a month in advance, I might not have diarized this matters today for different matters. So it's important to inform your lawyer, if you are making use of a lawyer, to be available on that specific date. Okay, if they notice to appear for the maintenance inquiry, in the main notice to appear, my apologies, for the maintenance inquiry, it is requested that you bring proof of all expenses and income from you, for you and the minor child. This is why it is very important for you to keep all proof of expenditure in a safe place. Hint, if you can afford to bring an original proof of expenditure and income and a photocopy thereof, the original you would then be able to take back home and bring it back when requested. And a copy will stay in the court file. I must squint my eye to see what's happening on the screen, but I hope you follow where I'm going to. So what are we trying to tell the parties here to do? Please remember, you might say, my salary slip says X, Y, and Z, and you come to court with one copy of your salary slip. That might be a bit problematic because the other party might want to see it. The court would like to have their copy, or they keep the original in the court file, and there it is. You can't get it back. So a good idea is make photocopies, have a copy for the court, for you, of course, and the other side, the other party, the other parent. It will make life much more easier. And also when you are presenting your case to the court, you will have copies in front of you which you can give to the various parties to argue your case, as opposed to there only being one copy that has to move around. A lot of traffic in court, not a good idea. And the last step, step number 4. This step deals with a maintenance inquiry where you and the person from whom you are claiming maintenance from will appear before a maintenance officer. The maintenance officer will speak to each of the parties and look at the documents provided. Each party will get a chance to explain why he or she requires maintenance and also why he or she can't afford the maintenance requested. The maintenance officer will, as far as possible, try to resolve the matter there and then without it having to go to court. If the parties can agree to an amount, this amount can be made an order of court. If however an agreement cannot be reached at this stage, the matter, depending on the court, will either be referred to a prosecutor or for trial. Okay, my last point. Remember, if you are a father or a person currently paying maintenance or child support, a reduction is possible. The same goes for an application for an increased maintenance or child support. The last point before I deal with the other point would be that if you believe you're paying too much maintenance, you're welcome to approach a maintenance court for a reduction. If you feel that you require more money, you are welcome to approach a maintenance court for an increase. But nonetheless, the start of step number 4, there will be an inquiry. The court would obviously want to listen to both sides of the story. That is why it's very important to go to the maintenance court prepared with all your documentation, support, and so on. I always advise parties that maintenance is sometimes the easiest matter to be resolved. You can have a child custody issue before the court. Very complicated, a lot of emotions. What is in a minor child's best interest? Sometimes it's very hard to determine that. Domestic violence, again, a lot of versions, a lot of information being provided. However, regarding child maintenance, a bit more easier in the sense of it's a mathematical equation. If the father earns so much and the mother earns so much, the expenditure are so much, the child's expenditure is that much, it's easy to work out. Or we can be close to a sum as opposed to other matters of law. Nonetheless, that's our supposed to be a 3-minute guide. I think we took about, let's see, about 14 minutes to explain it. Nonetheless, thank you for joining, and I hope to see you online again soon. You can make use of Facebook Live, whereby you can interact with us via that specific platform. I'll obviously keep my eye on Facebook Live as well, so if you are watching this video via Facebook Live at present, feel free to pose your question there and I shall interact with you. Okay, we have somebody on Zoom who has registered and willing and wanting to interact with me. Great. I'm happy to hear that and see that. So hopefully we can have some great interaction. That specific person is the person that posed question 1. Okay, question 1 from Gauteng. It's a typical scenario which I deal with or I hear about quite often, whereby the maintenance officers, they do not deal with maintenance matters in the manner which they should, in terms of the Constitution, South African law, the Children's Act, and various legal pieces of legislation. Obviously, when it comes to matters concerning a child, the maintenance officer and the maintenance magistrate, they have a legal obligation to ensure that the child's best interest is upheld, that it is a constitutional imperative. And therefore, it's not for them just to try to dispense with maintenance matters as quick as possible, acting as judges, acting as magistrates, and not giving the rights of the claimant to them. That's very important to note. There's a legal obligation on all magistrates, on all maintenance officers, on all maintenance clerks to make sure that when a maintenance matter is being resolved in front of them, that due regard is given to all the necessary tools that the Maintenance Act has provided for them to make use of. That's very important. And it quite often happens, and this is my problem, it quite often happens where people approach a maintenance court. There are a lot of people in the queues, in the aisles, and the maintenance officers just dispenses with these matters ASAP, quick as possible. They do not give it proper due regard. And it's very important that if one party, for example, let's say the party that has to pay the child maintenance, does not come to the maintenance court with the necessary documentation, with the necessary information, and so on, the maintenance officer must not dispense with this matter until it has determined that all information is before it. And once it has done that, the same applies to the mother and the father, both of them. All information is before it to determine whether or not a fair maintenance amount would be made, a maintenance order would be made. And until only then can the matter be dispensed with. It is not for the maintenance officer to say, you know what, in our area, we only give maintenance of 1,000 rand per month because that's generally what we receive, despite how rich the father is or how poor the mother is, and vice versa. That is amount, which is obviously nonsense. Every maintenance matter must be dealt with on its own merits and on the facts and information before it, full stop. In a very poor area, somewhere in South Africa, an amount of maintenance of 50 rand might be a reasonable amount considering the circumstances. But in that same court,
if there is a wealthy person living there and a wealthy family living there, and the maintenance amount must be 50,000 rand per month, the maintenance court must make that order. And the same amount of effort that the maintenance court made in resolving a matter where the parents are wealthy and the children require a lot of money, the same amount of effort the court made in that specific case, the court would have to make in the specific case where the children, where the families are not as wealthy and are not as affluent. So I hope I've explained to you the role of the maintenance court. And if you are a maintenance officer and a maintenance magistrate watching this video, please make sure that your constitutional directive is being implemented. I mean, I done an appeal matter about 2 years ago in Grahamstown, and the judgment in the matter specifically outlined, said, I mean, the courts have a legal obligation to do their jobs. It's not to, deal with maintenance matters as a, conveyor belt, let's dispense with it quickly. They have to do their job. Okay, the question from Gauteng, question number 1, and thank you for waiting for me on Zoom. I will let you in the next few moments' time. Basically, it is a problem which the mother has. There is a maintenance order in place. She's going to the maintenance court on and off all the time. And the maintenance officer in this specific case, in my view, would have obviously tried to have this matter resolved as quick as possible. And the maintenance officer made certain, very proper decisions and advices to the complainant. So I've highlighted a few points, and which will obviously deal with, and the questioner can obviously deal with it a bit better now. What are the procedures to dispute a maintenance because I'm not happy with the maintenance officer ruling? I want to take the matter back to court for a formal inquiry in front of the magistrate. Firstly, a maintenance officer cannot make a ruling. He is not a judge, he's not a magistrate. But it seems to me some maintenance officers think they are that. So the maintenance magistrate would have most probably made the order, but the maintenance officer would have been the person that has obviously most probably tried to, push that this file be resolved sooner than later. Okay, I've highlighted the further points. I want to dispute the order because the officer was biased. The officer told me that I can't claim accommodation because it's my bond, so it's my problem. That is nonsense. If you have a bond, if you're paying a bond, the other party has no obligation to pay your bond. That's very important to note, but the other party has an obligation to pay towards the child's living expenditure, the child's accommodation. So your bond might be, I'm using a silly figure here, it might be 1,000 rand per month. Now you have to work this out. If you had to rent accommodation, right, and the accommodation would most probably be another silly figure, 500 rand per month. And the child's portion would have most probably 200 rand, because had you not have the child, you would have most probably rented 300 rand, paid 300 rand per month for the accommodation. That portion of 200 rand per month, that portion is the child's portion towards the accommodation. And the other party has to contribute towards that specific portion. So your bond might be 1,000 rand per month. You cannot ask the other party to contribute towards the 1,000, but you can ask the other party to contribute towards the 200 rand per month, because that would have been what it would have cost the child to live in any event. Okay. So then the person goes further and deals with various other issues and problems. But then it concludes, I want the court to look at this. Please advise me, frustrated mother. Okay, Mom, I will allow you to join via Zoom, and you can just comment a bit further or interact with me a bit further, and we can take it from there. Are you online?
Yes, I'm still online.
Wonderful, yes. Do I have the gist of your question? Do you want to add anything else before I go further and try to give you some advice regarding this?
Expenditures and child needs, and other things were cut out of my plate. That's my challenge. That's why I wanted to
for some other reason, the sound is not coming so well through that. Okay, so I think we have some technical difficulties with getting the Zoom into the specific question over here. Okay, but nonetheless, let me deal with that question holistically, what you can do. I think that is what ultimately what you want to know, what you can do in the specific scenario. I think that's very important to know. So let me deal with that quickly. Let me just obviously there is a maintenance order in place, right, which a mother is not happy with. The challenge you have is, the question is, are you going to appeal that specific magistrate's decision? Because the magistrate made the order based upon, obviously, and I'm looking in between the lines here, it should have either be done via an agreement, or the maintenance officer asks you, ma'am, are you happy with this? And you, of course, would have said yes, and they made an order. If you said, I am not happy with a specific recommendation of the maintenance officer, the matter would have proceeded obviously to a trial, where the magistrate would have obviously called the mother as a witness, and she can testify as to the expenditure of the child, and they would have called the father, and he would have obviously have done his thing and explained why he cannot afford it or what he can afford and so on. But that did not take place. So the question is, can I appeal the specific decision? Now, my view on the specific matter, appeal must probably be very exhaustive, because the court file might be empty. And if you are going to appeal the specific decision, what would the appeal court have before it in trying to come to some type of an answer whether or not the maintenance officer made a proper decision or not? So I would most probably say, do not appeal this decision. And there might be some documents stipulating that you actually agreed and you accepted the amount offered by the father. I do not know when this application was, obviously the order was made, but it doesn't seem to be too recent. I would actually approach the maintenance court again and advise them that these are the current income, my income, and these are the expenditures of the child. It is far too little. I cannot survive from this specific amount of money that is being paid to me as child maintenance from the father. And I would like to have the current order, re-looked at. Number one, firstly, because it is too little. And number two, the father can afford much more money, but an inquiry needs to take place to confirm that. So basically, we're asking the court to deal with this matter afresh, but properly. Firstly, factually, you cannot afford to survive off the amount of maintenance being paid. And secondly, a proper inquiry did not take place in looking into the father's circumstances. And you are fully of the view that the father can afford the amount of maintenance being claimed. Are we on the same page with that is concerned? You're welcome to comment if you can get through. Okay, so that will be my advice to you. Go back to the maintenance court and say the father can afford this amount and the amount currently being paid is too little, and do that as soon as possible. When was a court order made, if I may ask?
Yes, thanks. Okay, then what is the substitution or the discharge?
Sorry, the question now was, my apologies for that. The question was, is it an application for substitution or discharge? The answer to that would be that it would be an application for a substitution of the order. So you changing the order for a new order. So the current order is most probably X amount of rands per month, and he should pay for the following. You're asking the court now for an order to be substituted with that order for a higher amount of money, and for him to pay other things as well. A discharge application would basically mean that there's no need for a maintenance order. As mentioned earlier on, and I think it didn't appear that where the father will apply should the minor child be maybe 18 years old and self-supporting, or the father lost his job completely and is unable to pay the child maintenance, then he will apply for discharge. So discharge, order falls away, substitution, we're putting in a new order in his place. So that basically deals with that. So wonderful, thank you for that interaction. Okay, but I'll chat to you a bit later afterwards on Zoom, and maybe we can have some video chat where that is concerned. Okay, let me get to question number 2. Question number 2, quite a interesting question. My maintenance file spans from December 2010, which is quite standard these days. Very, very sad that people have to fight for maintenance for 11 years. Okay, she tried to get hold of the father, subpoenaed X, Y, and Z. He moves from one court to another court. What I have highlighted was I have 3 children who have suffered through this, and I'm needing to ask, is there any hope? And the last question would be, at the end of that question was, not sure where to turn to or how to begin again. Okay, the difficulty which I have in sometimes advising clients from a distance, where I'm sitting here from in my office, or I can call it an armchair. I do not know what difficulties you have gone through, what you have done, the challenges you have endured, the other party, his attitude, what he's done, the maintenance court dynamics, and all those things. I'm sitting from an armchair from a distance away. It's like someone playing a football match. It's easy for me just to talk here and give you the advice on how to win that match, but I'm not there. I need to be in the mix and in the battle in order for you to fight for it, because it's impossible for me to advise you what move to do unless I am there dealing with the matter. So when I'm dealing with the matter, I can obviously apply my mind to it and say, okay, this might work, that might not work, test it, okay, did not work, let me try this, and going forward. The bottom line is the maintenance courts have an obligation to assist parents in obtaining child maintenance. If the other party has an attitude, sorry about that, if the other parent has an attitude in the sense of I will not pay maintenance, I do not want to pay maintenance, I'm going to make it very hard for the other party to obtain maintenance from me. That is the attitude. And that person makes it very difficult. So in the specific example, the person works as a consultant, the specific person hides money away, only a little money comes to his bank account, and that money which goes into his bank account, he or she shows to the maintenance court. Let's say, for example, 10,000 then comes to his bank account for his business, but 100,000 goes through cash deals, or via different bank accounts that we do not know of, that we do not have any access to, or any knowledge of. So that becomes very difficult. And I find it very sad that we have people out there like that. I have no problem with a father or a mother who has to pay maintenance and says, I do not think it's fair for me to pay for the X, Y, and Z. That is fine. Let us debate it, let us discuss it, and let us come to a decision. But he puts everything on the table, or she puts everything on the table, his income, his expenditure, and also the mother has to do all of that. She has to explain what her income is and what the expenditure of the children are, etc. And we can debate it and we can argue it and we can say, okay, no, you want to pay 1,000 rand, we want 1,300 rand, let us meet in the middle, let us resolve it. But I have major problems with people who know the child costs 1,000 rand per month, in my example here. But he or she will make it sure that they only pay 50 rand maintenance, despite them earning 20,000, 30,000 rand per month. They'll make sure my mission in life is to pay as little maintenance for my child as possible. I will go to the ends of this earth, pay lawyers, do whatever I can do, earn maybe less money even. They'll do that. Because they'll say, if I earn more money, I must pay more maintenance. Therefore, I will not get a promotion at work. I will earn much more. I will earn much less money in order for me to pay less maintenance. And that is very, very sad. And you have that out there. You have people like that. So those are the parents from the other side, the father or the mother, that I find it very difficult to advise you when it comes to those specific parents, because they are not playing the game fairly. Their mission in life is not to pay. The other parent, on the other hand, is someone, as I mentioned earlier on, he outlines his income and expenditure fairly, his salary, and there's a debate and discussion as to what is reasonable or not. That is fine. I have no problem with that, because what's reasonable to the mother might not be reasonable to the father, and vice versa. So my advice to you for the specific questioner from Gauteng is relook at the entire matter. Analyze it from a point of view. You know this father, what his ways are, what he does, how he hides his money away. What is his modus operandi? How does he operate? That's very important. But at the same time, ensure that your specific case is foolproof. You have full details of your income, your expenditure, the children's expenditure, the children's needs, and so on. And then approach a maintenance court from that specific angle, from that specific attitude, and make sure that the maintenance courts assist you. If it means going to the maintenance officer's manager, going to the court manager, doing whatever you need to do, make sure the maintenance court makes it possible and makes it happen that you obtain the maintenance you're entitled to. In all honesty, and I'll be honest with you watching this video, and if you're a maintenance officer, magistrate, clerk of the court, whoever you are, the tools that are afforded to you in terms of the Maintenance Act, the Old Maintenance Act, the amendments of the Maintenance Act that came in a few years ago, if you use all those tools and you're getting paid for that, you're getting a salary for that, if you use all those tools, every party who has to pay maintenance, who's trying to hide from the system, will be brought to task if you use those specific tools. But the sad thing is they are not using those tools. So my advice to you is, the questioner from Gauteng over here, I do not have a one answer, do this, do that, that will fix everything. I'm saying there is hope. Make sure your documentation are in order, go to the maintenance court and make a noise. And until the maintenance officer does his or her job, you do not leave the offices. They are maintenance investigators. People can investigate you. The Act allows that. Many people believe that they are only maintenance officers. They are maintenance investigators. They can subpoena people. They can go to the banks. They can get data for you to assist you in obtaining your maintenance. I hope that assists you where this is concerned. If you look at the scenario, you will see the word garnish orders. You see various things that the specific party done. But the bottom line over here is we need to show the other party that you mean business, and the maintenance court must assist you in doing that business. Sorry about that. Okay, question number 3. Interesting question. Am I entitled to claim back maintenance? Okay, so let us just get the screen right. Okay, am I entitled to claim back maintenance? So there are two scenarios that may be of application. Number one would be there is no maintenance order in place. Let us say the mother and the father live together. The child is 5 years old when they separated. The child is now 6 years old, and the father never paid any maintenance for the last year of the child's life. Now, the question might be, can I claim back maintenance? Can I claim maintenance from when I left the father until now? That's one scenario, and I'm using simple figures here. There might be legal terms to refer to that. The other scenario would be, can I claim maintenance that the party has not paid the maintenance in terms of a maintenance order? So there's a maintenance order in place. You've done nothing for an entire year. The party was ordered to pay 1,000 in maintenance. You've done nothing for an entire year. Can you still claim that maintenance going back? Okay, so let's deal with the first scenario. Yes, it is possible for you to approach a maintenance court if the other party has not maintained the child despite there not being any maintenance order. So in my scenario, you can approach a maintenance court and tell the maintenance court, you know what, I separated from the father of the minor child a year ago. He has not maintained the minor child for the last year. I would like to get money from him for the last year because it cost me 1,500 rand per month to look after the child for the last 12 months. I would like him to pay half of that 750 rand per month. And at the same time, I would like him to continue paying the 750 rand per month going forward, plus inflation, plus CPI, or 10% increase every year, and so on. That is possible. So the question is, am I entitled to claim back maintenance? Yes, you are. You're allowed to claim it. The court will obviously come to a decision as to what would be a fair and proper amount. Okay. Regarding should someone not pay maintenance in terms of a court order, my fictitious scenario, which I'm putting out there, yes, a maintenance order remains valid, and the maintenance amounts owing in terms of that order remains valid indefinitely. Therefore, if someone has not paid maintenance for the last year, you can approach a maintenance court, and the maintenance court can obviously attach his salary, attach money from him, go into his bank account and take money from that, etc. And it is a criminal offence not to pay maintenance as well in terms of a court order. Okay, I think that deals with that specific question, question number 3. Question number 4. Okay, interesting one, and I put it on for the sake of doing this. I do not require legal advice. I want to attend this session as I intend to proceed with pupillage in the near future. And this is one of the facets that I have a keen interest in. I would like the opportunity to attend this session to gain more knowledge on the topic and to understand how to handle problems of this nature. Okay, that's wonderful. Pupillage meaning somebody who has a law degree and would like to become an advocate. So that's great. You're welcome. Thank you for your comment. And I hope you'll become a very good advocate one day. Question number 5. Okay, another long question, and obviously something I would like to assist you with. So this specific person has twins turning 15 this month. Okay. The father had been paying 2,500 maintenance for the last 3 years and 1 school fees and help school clothes for the 1 child. He's supposed to buy them clothing for when he has them for on holidays and so on. So the mother cannot afford to pay for the school clothing, and she's sending the kids on holiday to him, and hopefully he will pay for that. The children are supposed to be on her medical aid, but he did not. Sorry, on his medical aid, but he did not do that, and now the children are on her medical aid because of work. The work is allowing that. Okay. What I have highlighted further was, I have asked him to increase it, and I'm not asking for a ridiculous amount of money, but he hasn't budged. And she goes further, the girls have needs, and I feel he needs to play a bigger financial role. He is remarried and has 2 children. Beginning of this year, he started working overseas. He comes back 3 months and goes back. This is a question. I want to know if he isn't in the country, could his wife be subpoenaed to court on his behalf? So that's basically the question. The person is complaining about him not doing what he's supposed to do. So let us deal with that first. As I mentioned earlier on, if someone is not adhering to a maintenance order, you have a right to enforce that order, either criminally, the maintenance court would advise you, of course, what's the best channel, either by the criminal courts, and if they find him guilty, you could possibly go to jail, or by the civil route where they can attach his property, get a garnish order, get his boss to pay the arrears, and so on. So that's the options which you have. So go to the maintenance court as soon as possible. If you want him to pay more and he's now saying he's not budging, he doesn't want to, you may still approach a maintenance court and ask the maintenance court for an order for the substitution of this order with a greater amount and so on. So those are the options which you have where the maintenance court is concerned. Regarding your legal question, which is, I want to know if he isn't in the country, could his wife be subpoenaed to court on his behalf? The answer is no. There is no legal obligation on step-parents to maintain step-children. There is no legal obligation. Tomorrow, the parties might divorce again, and then does the maintenance order still remain intact? Let's say, for argument's sake, to explain the scenario, let's say, for example, that was possible. The father marries another lady, she's very wealthy, and you take her to the maintenance court, the court makes an order that she should pay the stepchildren 1,000 rand per month. Tomorrow they divorce, must she continue paying the 1,000 rand per month? She's no longer married to the husband. So there is no legal obligation upon step parents to maintain stepchildren. It's very important to note. But what is interesting, and which you have to apply your mind to it, and maybe, hopefully, you'll figure this one out, is that if the father got married to a lady, and they were married to each other in community of property, then there is now one estate, a joint estate. Then that specific estate would be responsible for the child maintenance. So if the father earns very little money, apologies. If the father earns very little money, but his new wife earns a lot of money, that goes into the joint estate each month, and then that specific money can be used to pay the child maintenance of the children. And in her regard, her stepchildren, and in his regard, his children. So that's why it's very important to know how the parties are married. Are they married in community property, whereby the joint estate can be responsible to pay the maintenance of the children, or are they married out of community property, whereby what belongs to the father belongs to the father, what belongs to his new wife belongs to her. And under those circumstances, you cannot get any money from the new wife to pay for the father's children's maintenance. The new wife, of course, has an obligation to maintain her husband. Okay, I hope that answered that specific question. So my advice to you, as I mentioned earlier on, go to the maintenance court and ask them to assist you with that. Okay, question number 6 from Gauteng. We're having a lot of questions from Gauteng, and I think, yeah, a lot of questions from Gauteng. Western Cape, please join in this. I think we have a few questions from Western Cape that I will be dealing with tomorrow. Remember, tomorrow's webinar is 12 o'clock and not 11 o'clock. Question number 6. I have a maintenance case. We attend our first date. Then the father said he needs a DNA test to make sure that the kids are his. The DNA test date was the 26th of October. That was the last month. Then the mother went to court. I found this guy saying the doctor's letter to say that he's tested COVID positive. Okay? But he comes to sign our OB book. The maintenance court is going to help me. So I do not reword these questions. I post them as they are, unless someone spelled the word maintenance wrong or court, and I change those specific things. But nonetheless, so here the father is saying, okay, I'm not the father, I'm not sure I'm the father. What happens then in the maintenance court? So we'll unpack this specific scenario. Remember, you are only obliged to maintain your own children. You're not obliged to maintain someone else's children. That's very important to note, and I think we all understand that specific concept. We're not obliged to maintain someone that's not relative to you. Therefore, if this father is not the father of the minor child, how can we proceed with a maintenance inquiry for him to pay maintenance towards his minor child if that specific issue is not being finalized? It doesn't make logical sense. I mean, you can have a problem whereby a mother can intentionally, not saying my scenario, this example is obviously a legitimate scenario, but you can have a problem where a mother can say, oh, that guy is very wealthy over there, a lot of money. Let me approach a maintenance court and tell the maintenance court he is the father of the child. Yes, I met him once, so you can't dispute that. There's a few photographs on Facebook about with us together. So, I can bring up an argument that I am the father of the child, so that he is the father of the child. And then that's it. Then she has a wealthy father to look after the child, despite her knowing who the other father is, who the real father is, and he's not as wealthy. Therefore, the DNA test needs to take place. Once paternity has been confirmed, of course, then the matter proceeds as usual. Therefore, I do not, obviously, we're dealing with COVID-19 here, and if the father has been excused because of a doctor's note stipulating that he is COVID-19, unfortunately, we have to now wait for that specific few X amount of days. Those days changes so often. But let's say you have to wait those 2 weeks for the finalization of the specific issue regarding the COVID test. And once the COVID test is once the paternity issue is finalized and he is confirmed to be the biological father, remember, you're welcome to ask the maintenance court for maintenance order to be backdated in lay terms from the date when the father stopped paying maintenance, or he did not pay maintenance, or the date of the birth of the child, whatever the case may be. So the delay because of COVID-19 and the paternity does, unfortunately, it is inconvenient to you. You need the money, but it does not mean that you will not get the money which you have expended for the minor child. Okay, I think we've done well today. Those are the 6 questions, and I think we dealt with it quite in depth. There's quite a few questions that were posed. If you have a question, yes, sometimes, and I think it seems to me it's about 10 or 15 questions gets posed at a time. Sometimes just comments, but please pose your questions using the various platforms mentioned below me, but further below this window. And I would like you to interact with us via Zoom. I think we had a technical problem regarding Zoom. We'll try to fix it by tomorrow with the IT department. But nonetheless, thank you for joining this webinar, and I hope to see you online again. So tomorrow is 12 o'clock. Have a lovely day. We're going through. Remember that, what time things get better. But nonetheless, my aim today is to resolve whatever problems you may have. So we started a new platform since last weekend, Thursday, whereby you can pose questions before the time. You email it to us. We respond to you, telling you we will be dealing with your question the next day or the following day, depending upon when you send us your question. If you send a question to us, for example, like now, we will deal with it the next day. If you send it to us, for example, the later evening, unfortunately, we'll only deal with it the following day, because during the late afternoon, we send you the details for the next webinar, the Zoom details, and so on. But nonetheless, there are various platforms you can make use of. You can join us now live via Zoom, and I'll be able to interact with you immediately. Or you can join us in a different format via Facebook Live, the Advocate Mohammed Abduroaf Facebook page, and you can type a question, whatever the case may be, and I will deal with that. But we have today 7 questions that were posed to us yesterday or the night before, and I would like to deal with those today. But before I move on, a person has posed a question. That person is with us live via Zoom, and I would like to deal with that question first, just to be fair to everyone. And it deals with issue concerning whereby a minor child, or a child is now 18 years old, a major, but before the child became an adult, there was a maintenance order in place, ordering the father to pay the maintenance to the mother. So what happens then? Now the child's an adult. Do you still pay the mother directly, or should you pay the father, or can the father pay the child directly, and so on? Okay, so with me, I have the person online. Are you still with me via Zoom? You're welcome to add additional comments, engage with me, and I'll be able to assist you. The person on Zoom, you're welcome to go ahead.
Thank you very much, Advocate Abduroaf.
You're welcome. Yeah. So do you want me to answer? Do you want me to answer the question based upon the information you provided, and then you can maybe pose a question afterwards? Would that be better for you?
That would be ideal. Thank you very much.
Wonderful. Let's do it that way. Okay, so this is how it works generally. The child is, let's say, 10 years old. The mother goes to the maintenance court. There's a dispute, which is normal. I mean, the best of fathers. I do not agree, as I mentioned in my previous webinars, you should not automatically disagree to whatever is requested by the other parent. You need to discuss it, debate it. If the court analyzes the matter and the court comes to whatever amount, and that be it. But many times I have dealt with matters whereby the mother requests a very exorbitant sum of money, quite a high amount of money, and then it goes to the maintenance court, and the court halves those amounts because it's only fair. But nonetheless, in our specific scenario, some time ago, the parties were embroiled in a maintenance matter, I presume so, and at the end of the day, the court made a maintenance order. The child was a minor at that time, under the age of 18 years old. Now the child is an adult, he's 18 years old. The challenge we have now is the child is not yet self-supporting. I mean, many kids are nowadays 18 years old, still in grade 11 or 12. The child is no longer self-supporting, so the law, of course, says that while a child is not self-supporting, both parents still have a legal obligation to maintain the minor child. The difficulty we have over here is that the order is in favor of the mother and the child is still with the mother. So the question is, should the father continue paying the maintenance to the mother and the mother pay the maintenance to the child? Or can the child, or can the father pay the maintenance directly to the child as opposed to the mother, because now the child is an adult? The law, which I have looked at some time ago and which I have applied in the High Court quite a few times, is clear that until the child is self-supporting and there's no cut-off date in the maintenance order, that's a very important point. If there's no cut-off date, if the order says the father should pay the mother maintenance, full stop, and there's no cut-off date, it doesn't say, for example, that the maintenance should come to an end at the age of 18 or 21 and so on. It basically means that the maintenance will continue until the child is self-supporting. The father should continue paying that maintenance to the mother, because the mother is the one caring for the minor child, despite the minor child being an adult. The only possible way to get around that would be for the child and the father to go to the maintenance court and stipulate, you know, I am not self-supporting, but I am an adult, because I am an adult. You know, I'm no longer a baby, I'm no longer a child. I am adult, and therefore I would like the maintenance order to be set aside and for my father directly to pay me. So that would be the only way I can see that you can deal with a specific matter as opposed to paying the mother. But there's no other way which you can deal with it, in the sense of going to the maintenance court without the child being involved and saying I would like to pay the money directly to the child, if the child is not part of that equation. I hope that answers your question to some extent.
Absolutely, absolutely. I wanted to clarify that there is no dispute from my side that the maintenance must continue. But the query is, how does he pay to the mother and knows that she's not in the equation anymore? But he answers the question, so ultimately he would have to be involved and he would have to make a appeal to the magistrate to see it.
Yes, that's exactly what I'm saying, because he is an adult now, so he can decide.
Yes.
Because the reason why I'm saying so is many times the child is still in high school or in grade 11 or studying, maybe tertiary education, but still a little one, and he goes to mom, makes his bed for him, or those 18 years old, mom gives him food, mom attends to him like a child, and he's trying to make his way out in the world. So I appreciate and I think it's wonderful that you are involved, but I understand, you know, and I gripe with this law. Honestly, I had a problem with this, and maybe the law must be re-looked at, because I would presume once a child turns 18 years old, the child and the mother and the father should approach the maintenance court, and then the maintenance court can now decide at that point, should the order remain in the name of the mother, or should it be transferred into the name of the father? But the law hasn't developed in that specific regard. But thank you very much for your question. I appreciate it very much, and you're welcome to pose any other questions in the future.
One last question. What is the difference between discharge and set aside?
Yeah, they're basically the same. So this is, I wouldn't want to give you a technical. There might be a minor technical thing, but the outcome is exactly the same. There's no order. The order is set aside is also like it's gone. Discharge means basically there's no need for it. So you will basically set aside the order if you say there's no need for an order because the father no longer can, for example, pay the amount of maintenance. So if the father says, I'm unemployed today, the child still requires maintenance, but I'm unemployed, I cannot afford to pay the child maintenance, the father will make an application to set aside the maintenance order because there's no use for it. For example, now the child becomes basically self-supporting and he can look after himself, then he'll say, I would like to discharge the order. Some to that effect. So the outcome is exactly the same.
Perfect.
Okay.
Wonderful. Very much. I do appreciate your time.
You're welcome. Thank you for you.
All the best.
Okay. Okay, wonderful. So that dealt with question number 3. So we'll jump back to question number 1, and please feel free, as you notice, interacting via Zoom, voice-wise, or as if you were face-to-face with me, it helps us a lot, because as I answer a question, you have another question, or I might have a few questions to you, and doing it via typing does not always help that much. Okay. Now the child becomes... Okay, let's deal with question number 1. Thank you very much, and that's from the Western Cape. Today we had quite a few questions. We had about 5 from the Western Cape, and we had 2 from different provinces, KwaZulu-Natal, and I think Free State. Yeah, those are the last 2 that came in. Yesterday we had just from Gauteng, and Gauteng was probably got tied with our webinars today. So question number 1, quite a straightforward question. I have a son of almost 2. Our parenting plan says the biological father may only see him when his mother is there to supervise. Okay, parenting plan, supervised contact, and the mother is a supervisor. So supervision doesn't necessarily mean the mother must be in the same room and watching over the father. The mother must be in close proximity. So should the child require the mother, or should the father be unable to care for the mother, should the child cry, and then the mother is close by. But supervision doesn't mean the moment the father does something wrong, because how will the father know on how to, or learn to be able to interact and engage with a minor child if he doesn't get that opportunity? So if the child does cry initially, the mom must stand back, give the father some time, give him some space to figure out how to pacify the minor child and so on. But the child is almost 2 years old, so it's quite young. But the parenting plan says that contact should be supervised by the mother. The question is, am I allowed to say that he is not allowed to pick my son up without her? So, presuming collecting the minor child without the mother being present. May I get a passport for the minor child? So that's the second question, okay. So, if the order says, the parenting plan says that contact must be supervised by the mother, then of course the father cannot collect the minor child and be alone with the minor child, driving around to whatever place without the mother being present, because the order says it must be supervised by the mother. So that is it, and I cannot take it anyway further. The next question is, may I get a passport for my son when he has my surname, or do I need the letter from the biological father? The father is not mentioned in the birth certificate. Okay, so the child has the mother's surname, and the father is no longer in the birth certificate. Now, that is not a requirement for guardianship rights. In terms of South African law, both guardians must consent for a minor child's application for a passport. Section 18 of the Children's Act. Simple, clear as that. However, you have to be a co-holder of parental rights and responsibilities of guardianship. In this specific example, clearly the father is involved in the child's life. He has supervised contact. So I cannot argue that the father does not have parental rights and responsibilities over the minor child, or guardianship. He's involved in the child's life. So therefore, under these circumstances, based upon these 4 lines of data I have over here, in that specific scenario, I might be totally wrong. There might be other facts. There might be certain reasons why contact is supervised, etc. But generally, the father's consent would be required for the minor child's application for a passport. I hope I answered that specific question. That would be the easiest way to deal with the matter, because the Department of Home Affairs will ask, where's the father? And now you come the long story, X, Y, and Z. Let him be there. Let him give the necessary consent. Question number 2. Have a court order for 500 rand a month, which is more than 10 years old. Father agrees to pay school fees, but he fails to do so. School now sending me letters. Do I go back to the court for an increase? Yes, simple as that. You go back to the maintenance court. And my advice to you is, if you have spent much more than 500 rand per month on the minor child, and the father could have afforded to pay much more than that, for argument's sake, let's say the child cost 2,000 rand per month, and the father could have actually afforded to pay more than 500 rand per month, and it sounds fair, logical, compared to your salary and so on, then I would ask you to approach a maintenance court, asking them to backdate the maintenance order. So that is possible. The maintenance courts do not like doing that. It's a bit complicated, because how do you work on backdated maintenance, or backdate the amount? But it's possible. So, but the bottom line is, your question, go to the maintenance court as soon as possible. At least change the order going forward. The third question we dealt with early on. The questioner phoned in via Zoom, and that has been resolved. Okay. Let's deal with the next question. Question number 4 from the Western Cape again. I'm keeping an eye also on the Facebook Live. If you have a question via Facebook Live, feel free to pose it, and I will try my best to deal with that. Yes, I see we have a comment over here from Facebook Live. This is a very informative question and answer. Thank you. You are totally welcome. And I see we have another comment there, so I'll deal with a comment a bit later on. Please feel free to post your comments on Advocate Mohammed Abduroaf Facebook page. Let us deal with question number 4. Thank you for question number 4. What recourse do you have if the father refuses to swap visitation due to non-negotiable appointments? In this case, the appointment was caused by the father. Okay, let's say, for example, you have a non-negotiable medical appointment. The child must go to the doctor, or you should go to the doctor, and you would like to swap contact because of something very important. No final divorce order, no parenting plan previously agreed to. I don't believe it is in the minor child's best interest. Father also refused to adhere to COVID protocols during isolation and said he had the right to remove the child early. So these are obviously parental disputes. So how do I answer that? It's very difficult to answer what you can do. Obviously, there should be a parenting plan, so I would advise you to proceed and try to have a parenting plan entered into as soon as possible, so these type of problems can obviously not occur in the future. So the parenting plan, also maybe have a facilitator appointed, so that should there be certain issues that arises like this, that the facilitator can resolve these specific matters. You know, it's very difficult for parents sometimes to resolve these disputes despite there being a court order, despite there being a parenting plan, despite there being a facilitator, because of the attitude of the other party. And my thoughts goes out to those type of parents, because the reality of the matter is, if somebody really does want to frustrate your contact or make your life difficult, they will do so, and they will continue doing so. They might stop for a few days because of the court order, because they're complaining, but they will do so. But nonetheless, my advice to you is finalize a parenting plan, finalize all these things, you know, have a well-drafted document that deals with all these type of problems should arise in the future. And that's the purpose of a parenting plan. A plan on parenting the minor child going forward. That is your plan. Each family is different. All circumstances are different. We all know that. That's how it is. One child might be 10 years old, but the father might be doing this work, the mother might be doing that work, he might have a sister, might have a brother or not. Another child might be a single child, and the parents might be, you know, people that travel the world all the time. All dynamics are different. So when you have disputes or issues, the plan that the parents have, the parenting plan, needs to be unique to their specific situation. Okay, I hope I answered that question, question number 4 from the Western Cape. Question number 5 from the Western Cape. Okay. Spousal and child maintenance non-payment advice for court date on November 24. That's coming. Have excess bank documents showing monies hidden in another bank account, falsifying his personal bank account with narrations that even though in his bank portfolio says that account are not his, and the lies goes on. Okay, so I think that's more like a statement. What do you do? Spousal and child maintenance, that's the comment, the start, the opening comment. Okay, what advice can I give you? I do not specifically know what the question is or what the problem is, but you need to expose this to the maintenance court. Remember, a maintenance amount that the party must pay is based upon the facts of that specific case. You cannot argue to the maintenance court that the father or the mother earns millions of rands and despite the other party disputing it. So the father says, I'm not earning so much money. Whose version does the court take? Your version, where you're saying, I believe he earns thousands of rands, but I do not have the proof thereof, or the person who is being accused of earning thousands of rands. Of course, they'll take that specific person's version, because when a magistrate or a judge sits down and he gives a judgment and he gives an order stipulating that maintenance is 500 rand per month or 1,000 rand per month, he must justify that decision, and it must be based upon factual information that was presented to him. It cannot be presented on hearsay, on conjecture, on speculation, and so on. It cannot do that. Therefore, in this specific questioner's statement, I will stipulate, great, wonderful, you have bank statements, show that to the maintenance court, prove to the maintenance court that money is coming in, and that is how you're getting the maintenance amount you are requesting. I hope I answered that question. Bottom line over here is present your information, get data, and show it to the maintenance court. Okay, question number 6 from the Free State. Welcome, Free State. The question is as follows. My son, 7 years old, autistic, and ADHD, claims that the father's partner hits him when he visits during June holidays. When I ask the father, he is defensive and not willing to get to the bottom of the issue. I believe my son because he told me that the partner changed TV channels while he was watching. He threw a tantrum and she slapped him. He does not express himself well, and daddy does not give himself time to understand him, nor even spend time with him during these visits. What should I do to protect my son? Okay, that's a very difficult one. Easy to answer maybe theoretically, but pragmatically it might be a difficult scenario, because here we have an issue with a child that has these challenges, and we have parents who or partners from the other parents that does not appreciate and comprehend on how to deal with this, because every child is different. You know, each family unit is different, and we need parents to act as parents and be able to be mature and deal with these type of things in a very mature and a logical fashion. So therefore we expect the new partner to appreciate that the minor child has these challenges, and he or she must be able to have patience with it. And also the father, when he is exercising contact, he must be able to, engage with the minor child appropriately, and also to assist the minor child in enjoying the stay at his specific home with his new partner. But this is my advice. This is the only possible advice I can say, because if you're feeling that the father is not doing what he's supposed to do, this matter must be addressed. And usually these specific problems are addressed in co-parenting meetings or co-parenting sessions, where you speak with an expert, where the mother sits down with a professional person, and this professional person listens to the mother's issues. This specific professional person listens to the father's responses thereto, and maybe also listen to the to the minor child, and see what the minor child has to say, and we can get to the root of the specific issue. Maybe speak to the step partner or the new partner as well. Find out what the problem is and how we can resolve it, because these issues won't be resolved from distance. You know, where the mother is at her place, and she hears 2 days later that this happened, and she does nothing about it, and the father and the new partner is there. No one is sitting on the same table and working out how can we resolve this issue. Maybe the new partner does not know that the minor child has certain challenges. Maybe, I do not know. Maybe the father does not know how to deal with this. Maybe the mother is getting information from the child, but it's being exaggerated, etc. I do not know. But where I'm going to with this is the parties need to sit down with a professional person and saying, we have a challenge here. We want what's best for the minor child. We want the minor child to have the best of everything and the best of parents and step-parents, whatever the case may be. But in order for that to happen, we need to sit down on the same table with a professional person and try to resolve it, because everybody wants what is best for the minor child. That's what we are here for. You know, step-parents, wherever you are, but people have certain personalities, and people have certain temperaments, and people can only deal with matters at a certain point. But with outside help, you might be able to do so. If that does not help, mom, Free State mom, then unfortunately you must make a decision. Am I limiting contact with the father, with a minor child, no longer holiday contact, maybe limited contact, less contact, and so on, but you'll have to make a decision where that is concerned. And ultimately, if it cannot be resolved, the matter will have to go to court, and then the court would have to make a decision as to what is in the minor child's best interest. Okay. That was from the Free State. Thank you very much for tuning in. And now we have the last question from KwaZulu-Natal. I think that came through a bit late-ish last night, but I managed to put it in because there will not be a webinar tomorrow. And I felt it only fair to deal with all questions today. We will be back online next week. KwaZulu-Natal says the following. What are my chances of gaining sole custody of my son in the High Court? The mother constantly files false allegations in the magistrate's court, so I've taken it to the High Court. She is clearly mentally unstable and using my son as leverage, which goes against his rights. Okay, I can only guess. I cannot give an answer. I do not know any further facts. What are the issues? What are the disputes? And so on. But the long and short of the matter is, if you can get an expert, a professional person to recommend that it would be in the minor child's best interest for you to get sole custody, then of course the court will more than likely follow that expert's recommendation, getting the family advocate's report and so on. Then your chances are become stronger because experts, professional people are recommending that and stipulating that. If you feel that the mother is unstable and you can prove she's mentally unstable and a mental instability has a negative effect on the parenting capability on the minor child, and at the same time you can provide the minor child with a better life or caregiving than the mother can, then of course the court will have to consider that, and that's the argument we have to take. Many people, I'm not saying the specific example, I'm not saying that at all, but many people assume that automatically they are the better default. So, for example, you might have a mother that she's very short-strung, she's very strict, and she sometimes gives the child a bit of a spanking, a bit of a scolding, and grounds the child, etc. But she's a good mom. You know, she does the job. The child gets very good grades, etc., looked after, etc., and so on. Now the father has a problem with that. The child complains. The question is a father a better alternative? We do not know. First, you know, realistically speaking, the child was never properly cared for by the dad. The dad was always a weekend dad, school holidays, with respect. I mean, that is the understanding the parties had. So the question is the fallback, the father, is he a better caregiver by default? Would he be able to care for the minor child better than the mother can care for the minor child? And that question I cannot answer. But if an expert comes to that specific decision, wonderful, the court would obviously have to consider that. So that's from KwaZulu-Natal. Thank you very much for that. And that's the 7th question. We had, if I counted, we had quite a lot of questions for the last 4 days. And the comment I have on Facebook Live, it goes as follows. The difficult part on that mother's part is that what if the father just assumes that he doesn't need to provide for the order and there is variances? Okay, now that's a comment. I do not specifically know which question that is. It could be the maintenance one. But nonetheless, thank you very much for that comment, and we always appreciate that. Ladies and gentlemen, that's the end of the specific video. If you have any questions, please use the advocate Mohammed Abduroaf. Sorry, you can watch it there. Visit in front of you www.ourlawyer.co.za/Zoom or live, and you would be able to get the Zoom link or pose your question. Yeah, so the /live would be the one that you can pose a question, and I will deal with that. And pose a question. If you're not available to be online, that's fine. Remember, the next day, the video will be uploaded, and you can watch it via Facebook Live or our YouTube channels as well. Have a lovely day, and thank you very much for your time and watching. More time to do what we have to do, so let's get into it immediately. Please note that you're welcome to post questions via the Zoom platform live. The details are on the screen, whereby a link will be sent to you with the Zoom details, and obviously you can interact with me live. Someone will be doing it shortly. Alternatively, you can make use of Facebook Live, the Advocate Mohammed Abduroaf Facebook page, whereby you pose your question while typing it in live as well. And obviously the normal way would be sending the question via our platforms, whereby you register the question, I'll deal with it, and of course you still have the option of joining us live. Okay, the first question, interesting question, and I would actually prefer the person that posed the question just to assist me a bit with this, and obviously I'll be trying my best to answer the question. Let me just close this window here. And that's it, okay. The first question from Gauteng, it goes as follows. I have a sleep-in domestic worker from Lesotho and pay her 2,500 rand per month, I presume. She's looking after my 3 minor children. When the maintenance officer did the calculations, for example, rent, groceries, water, etc., she also calculated her. Okay. My argument was that whether domestic worker stays with us or not, accommodation must still be paid. How can I want a domestic worker to pay whereas she is getting less money? Because that's where I'm actually stucking on. I'm not understanding the question. Well, is a maintenance officer stipulating that he is deducting your maintenance, your cost, the cost of the domestic worker, or is the maintenance officer stipulating the domestic worker is living on your premises, and therefore the domestic worker should pay rental towards you, or you should deduct that rental from a salary and so on. So I'm not very much understanding that part of the question. Okay, my question is that right for the officer to include domestic worker on the expenses? I do not understand how he or she is including the domestic worker in the expenses. Is it deducting, adding on, whatever the case may be? I have a good relationship with the domestic worker. So the caller, the questioner, if you can maybe unmute your microphone, maybe just get more into detail regarding this. What are we dealing here with? Is the maintenance officer stipulating, okay, the father must pay 1,000 and maintenance, for example, but he must pay less because the maintenance officer must also contribute towards the household expenditure? Can you maybe give us some clarity, and I'll deal with it properly?
Okay, good morning, everyone. The question was like, when they do the expenses, I write the child expenses on the list there. When they did the calculation for the household expenditures, they wanted to include her. Let's say maybe if I buy a grocery for 1,000 rand, and then they said that an adult is 2, and then the domestic worker is going to be 2, and then with my 3 kids, 1, 2, 3, that means the total, when they get it there for the total expenses, they're going to divide it by 7. They calculating the domestic worker on the expenses for the household. When they do the maintenance, they take out the portion for me and the domestic worker on the side, and they also put the children's ones on the side. I wasn't sure whether is it fair to include her on the expenses because she's living with us in the same premises.
Yes, I'm with you. So maybe I can just jump in here quickly. So the principle basically is, in a maintenance case, however you unpack your expenditure, whatever way you unpack it, the ultimate goal is to get the other side to contribute his or her portion towards the household expenditure. So if the domestic worker is providing a service for the minor children, and then obviously the father has an obligation to contribute towards that specific portion. But for argument's sake, let's say, for example, your rental for the month is 1,000 rand per month. Now the domestic worker also lives in the premises, and you of course live in the premises, and there are 3 kids involved. You must determine only what the portion of the children are. So I disagree. I do not follow the principle whereby the 2/3, the 1/3, all that. That is very confusing. It is not realistic. So yes, if the child, if you work it out this way, if you had a home and there's 5 bedrooms, I'm using the silly example because there are 5 people in your home. There's 5 bedrooms, and because there's a domestic worker in the home, automatically now you have to have 5 bedrooms. But had you not had a domestic worker, you'd have 4 bedrooms. So there's a value associated with the domestic worker working there. So the father does not necessarily have an obligation to provide the domestic worker with accommodation. So it's difficult for me to stipulate whether or not the maintenance officer was right or wrong, but the bottom line is the maintenance officer must look at the matter from a point of view whereby what contribution should the father make towards the expenditure of the kids? Is the accommodation for the minor children X? For argument's sake, let's say your rental or your bond is 1,000 per month. What portion are the minor children using of that? And then based upon that, the court will have to determine what portion must the father pay towards that. I hope you're with me where that is concerned, but I don't agree with the 2/3, 1/3 practice which a maintenance officers work. It is impractical. It doesn't make logical sense to me.
Yes, I get it.
You know what I mean? Unless you want me to elaborate a bit further on the specific point, you're welcome to ask me more questions if you have.
Okay. Because when they deduct it with two portions, it's taking the money so low.
Yes, it doesn't make sense. And for the sole reason, see, I'm certain if you had to be a single lady, for argument's sake, and you had no kids, and you had no domestic worker, you would have a much smaller apartment. You for example, let's say your household, your rental, for argument's sake, let's say it's rental here, comes to 1,000 rand per month now with the domestic and the 3 kids. But had you been living alone, you must probably got in a place of 300 rand per month. But because you have 3 kids, you have to now spend an additional 700 rand for the 3 kids. That 700 rand must be split between you and the father. And I do not really understand why the domestic courts, complicate matters so much. It's simple. The father has an obligation to maintain the kids. What does the kids cost? And you do not work costs based upon a 2/3 and a 1/3. That doesn't make logical sense, because you can have a household with a 2-bedroom household where the kids are using only exactly half the household, and you work out a 2/3, 1/3. Although the mother is using half and the kids are using half, sorry. But here you calculate it on the kids only using 1/3. There's no logic in that. So you need to explain to the maintenance officer, or at least try to convince the maintenance officer, telling the maintenance officer, this is the logic behind it. Had I not had a domestic worker and children, I would have lived in a home that will cost so much money. But because I have kids, I have to provide for them. They cost so much money. Okay, but I have a domestic worker. But the domestic worker is here for the children. And 50% of the time the domestic worker is here is for the kids. Therefore, the father has to contribute towards the domestic worker's accommodation, 50%, okay, a portion of the 50%, and a portion of the domestic worker's income. Salary, where I'm going to. So it's not that very difficult, but it needs to be unpacked. So we do not confuse this whole thing with 2/3, 1/3, because I get confused myself, and I'm dealing with it almost for 20 years. It doesn't make logical sense to me. Okay.
Because my argument was also like, for example, let's say this domestic worker was not sleeping in. She was coming in the morning and going out. The accommodation will still be there. There's no half, there's nothing. The accommodation will still need to be paid in full.
Yes, I think now I'm following you. You're 100% right. For example, if you have a home, you 3-bedroom house, you and your 2 children, for argument's sake, let's say have a room. Now you bring a domestic worker in. A domestic worker sleeps in the living room, for argument's sake. You can't. It doesn't make logical sense to apportion the domestic worker. Because you'd have still had a 2-bedroom home, and tomorrow the domestic worker leaves, you're still, still dealing with the same situation where you are. Of course, you can argue that there's a need to have a domestic worker, and the domestic worker obviously has certain costs. I mean, because the domestic worker is living there, she eats, she uses water, electricity, and so on. And the father and if the domestic worker is used to care for the kids, for example, clean their room and etc. And half the time she cares for your part of the house for you, like does whatever she does for you, and half the time she does it for the kids. Then that half must be shared between the father and you. But you're 100% right. Whether or not there was a domestic worker living with you or not, that wouldn't have made a difference. It's almost like they're saying, okay, then let the domestic worker live somewhere else. It makes no difference. Like if she lives somewhere else, the maintenance will be so much. If she lives inside the house and sleeps in that room, the maintenance will be so much. So the maintenance officer is obviously not using his brains or her brains.
Okay. Yeah. Okay. It was just a little bit of my confusion.
I think that the bottom line is you need to just unpack it for them. Sometimes as maintenance officers, they cannot see the whole picture. They maybe deal with a lot of different households. Some households where they intentionally get an additional room for a domestic worker. They intentionally buy certain stuff for a domestic worker. And now they compartmentalize every household with a domestic worker in the same box. It doesn't make sense. They need to unpack your specific case with your specific facts, and deal with it accordingly. So maybe the best thing to do is outline it to them in a spreadsheet. This is how much my bond is, my rental is, whatever the case may be. Whether the domestic worker living here or not living here is exactly the same amount of money I'll spend per month. Therefore, it shouldn't be considered.
Yes.
Okay. I hope you all the best.
Thanks.
You're welcome.
Thank you so much.
Thank you. Bye-bye. Okay, that was question number 1, and thank you very much for the questioner for posing that specific question. Much appreciated. Okay, question number 2 from the Western Cape. Let me just have a look at our Facebook Live. I need to keep an eye on that as well. If you have any questions via Facebook Live, please feel free to pose it, and I shall deal with that. Okay, question number 2. Good day. I have applied for divorce since June 2017. That's 4 years ago, more than 4 years ago. The husband keeps delaying and changing attorneys. He has not paid maintenance since 2017. We are married income into property, and I moved out in March 2017 and is renting property. He is still living in the house. All 4 years ago, these things happened. He never paid maintenance for the last 4 years. Is there any way the divorce can be sped up as the matter is registered with the Western Cape High Court? He does not pay maintenance nor pay half the children's education expenditure. Can I proceed without him? Okay, so there's a divorce. I presume it's a contested divorce. The husband is opposing it, but he's delaying it. He's changing lawyers all the time. That is an unfortunate thing. But remember, in the High Court, at least, and I can vouch for this, the Western Cape High Court, there's no reason why things must be delayed. There's case management. There's things that are in place to expedite the finalization of a divorce matter. And 4 years is quite a long time. In all honesty, 4 years is extremely long. This divorce should have been finalized long ago. However, I do not know what your attorneys are doing. Your attorneys should know what they can do and to expedite it. There is something called, in terms of the High Court rules, Rule 43, whereby you can obtain interim maintenance pending the finalization of the divorce, and also to deal with care and contact and so on. My advice to you is speak to your attorney about the possibility of making an application in terms of Rule 43 of the High Court rules for interim maintenance going forward, and also contribution towards legal costs as well. That's also possible. But at the same time, there are internal structures, case management, to assist in the finalization and speeding of divorce proceedings. There is no need for this divorce to be taking so long. It should have been finalized by 2019 for the latest, before COVID-19, seeing that you applied for divorce in 2017. Okay, I hope that assists you with that specific question is concerned. The third question is from Gauteng. Deceased parent's mother was pregnant at the time of father's demise. Department of Home Affairs issued a breach birth certificate with no details of the father. Child has mother's surname and not father's. Parents married in terms of Islamic law. Please provide advice on how to correct and get a UBC. I think it's an unabridged birth certificate. Okay, I'm a bit confused here. Deceased parent mother. Did the mother pass away? The father passed away? The father's demise also. So I would presume the question here is, how can we, at the end of the day, get the child's father's surname on the unabridged birth certificate? But it seems to me the father passed away. So who has a right here? I do not know who is posing this question. The father passed away. He was a co-holder of parental rights and responsibilities. I do not think we can do anything much. The mother, maybe she can approach the Department of Home Affairs and ask them to get a new birth certificate with the father's details on. That is possible. I cannot see that being hard to obtain. But the second question is, if you are a third party, if you are the grandmother, if you are the sister of the deceased, can you approach the court for the child to have birth certificate, to have your brother or your son's name on it? I do not think what will be the benefit for you. Who will benefit? Is it the child's best interest? It's the mother that has to ensure that the child's best interest is upheld. It's a technical one, it's a difficult one. It's maybe possible going to the High Court, but I cannot see what benefit there would be in making such an application if you are a third party. If you are the mother, yes, maybe then you can, but it might complicate matters further because they'll keep on asking you, I see you as your father, this person is on the birth certificate. Where is he? Now you must explain all the time he's deceased. Maybe it's best to leave the person's name off. I do not know. That's up to you at the end of the day. And the fourth and last question from the Western Cape. Thank you, Western Cape, for joining in again. My son is 17 years old and he wants to live with my sister in the United Kingdom. He would like to study there and finish school. He has a British passport. Okay, so the child is 17, turning 18 soon, or would be turning 18 at some point in less than 365 days. He's a British citizen. But the father does not want to consent for the minor child to relocate. Difficult one, extremely difficult one. The reason why I'm saying so is, if the mother said, I would like to relocate with my child to the United Kingdom for a better life for my child, X, Y, and Z, the question would be easily be answered because the child is going with the mother. Here we have a scenario whereby the mother is saying, okay, more than likely I'm staying here in South Africa in the Western Cape, the father is in the Western Cape, I presume, but the child needs to go alone to the United Kingdom, but to be cared for by a third party, the aunt. Yes, the court can deal with this matter. The court will obviously have to make a decision as to what is in the minor child's best interest under these circumstances. Is it better for the minor child to go to the United Kingdom by cared for by a third party, the aunt, because he is a British citizen and he can benefit from that? That is for the court to determine. But however, on the flip side, depending upon when the child turns 18 years old, this is going to be important, because if the child turns 18 years old in the next 2, 3, 4 months' time, I would say a high court application will be a waste of time, because once the child turns 18 years old, the child can decide whether or not he or she wants to relocate to the United Kingdom or not, because then the child becomes an adult. So parental consent is out of the window. Okay, I hope that assists everyone. Thank you very much for joining and watching this webinar. Please note that our topic for the rest of the week would be relocation issues, passport consent, school consent, more of the issue concerning consent. The reason why we are dealing with that theme going towards the end of the year, because those are the issues which we are coming across much more. People wanting to relocate overseas, parents not consenting to school changes, passport applications, children leaving one school and going to a different school, etc. So those are the issues which we are dealing with now a lot, and I would like to educate our listeners where that is concerned. Thank you very much for your time, and I hope to see you online tomorrow again. Good morning. Welcome again to our live Q&A with myself, Advocate Mohammed Abduroaf. And today we continue with the issues of regarding family law. As you know, you can interact with me on various ways, via various ways. The first obviously would be via the Zoom platform, whereby you can call in via Zoom or join via Zoom and we can interact vocally. There is someone trying to get the audio sorted out via Zoom, so maybe later on we will have that person interacting with me, engaging with me. The other way would be to register a question, like some people have done. You go on our website, the details are all scrolling below, and you register your question, and I will deal with those questions at the next webinar. And obviously you'll get an email the day before with the details of that webinar. And of course, if you cannot make it, you cannot watch the video live, you can always go back on the Advocate Mohammed Abduroaf Facebook page or the various Facebook pages on YouTube and watch those videos, and I'll obviously deal with that. We try to commit to the questions that are being posed. And of course, via the Advocate Mohammed Abduroaf Facebook page, you can pose a question there. There were few people who have posed questions yesterday during our webinar, and for some or other reason, it did not appear timelessly on my screen, and I have taken the liberty of dealing with those questions. There are 3 questions, and they are below. So if you have posed a question on the Advocate Mohammed Abduroaf Facebook page yesterday, while I was dealing with the webinar and I did not see it or deal with it, I have indicated to you on Facebook that I will be dealing with that today as well. But nonetheless, let's deal with the first question from Gauteng. It goes as follows. I have a problem whereby the father of my child, my ex, does not want to sign the application form for the kid's passport. I lost my mom, of course the kid's grandmother, a year ago, and I would like to go with the kids to say our goodbyes in a proper way. As a family, we never went for the burial due to travel restrictions, of course, COVID-19 and so on. Home Affairs will not budge, so in this case, what do I do, as I cannot afford urgent application to the High Court? I will deal with that question. Thank you very much for that from Gauteng. Let us unpack it. The parties are divorced, I presume divorced, my ex. Therefore, the father would obviously, and 99.9% of the time, would have been afforded co-guardianship over the minor children post-divorce. So it's a co-holder of parental rights and responsibilities of guardianship over the minor kids. In terms of the Children's Act, more specifically Section 18, it says specifically, if a minor child applies for a passport, both guardians' consent is required. That's a requirement. So obviously the mother took the divorce order with, and they said, oh, if the father's a guardian, his consent is required, he should be here. They looked at the birth certificate of the minor child. Oh, there's a father's details on the where is the father. No, the father does not want to consent. Okay, Home Affairs says, okay, what we can do nothing. The father does not want to consent. He is not here today. However, Section 18.5 specifically says that the High Court or the court can overrule the father's non-willingness to consent to the minor child's application for a passport. Sorry about that. And of course, the High Court or the Children's Court can do that because they're the upper guardians of the minor child. You know, it's a common law authority given to the courts, the upper guardians. They have more authority over your child or power over a child than you have. So that's the court. So they can take the child away from you. They can put the child in another party's care. They can give you a right. They can take away rights and so on. So the concern, the specific question has from Gauteng is, yes, they watched my previous videos, I presume so, stipulating that you have to approach the High Court urgently. The Children's Court, they may be able to assist you, but it will be, this court might have that view that they can assist you, some courts will not, and you do not have time for that. I would say try the Children's Court, number one. We do not require legal representation there, not in the High Court as well, but obviously the Children's Courts are made to assist people without legal representation. And of course, they focus on children matters, where the High Court deals with a lot of other matters, commercial matters, evictions, people owing each other money, and so on. Go to the Children's Court, see what you can do. Obviously, hopefully they will assist you with the passport application. Very important to note, in the Constitution, every South African has a constitutional right to a passport. That's very important to note. So I do not think for 1 second that you will be unsuccessful in your application. You have strong merits. Even if you do not wish to go overseas, the child has a right to a passport. You're a citizen of the country. It's something which you're entitled to have from the word go. A passport, it identifies you with the country. Tomorrow the child decides to go away on a trip, school holiday, school excursion overseas to Lesotho, Namibia, somewhere close by. He or she requires a passport. So constitutionally, the child has a right to have a passport, but of course, and I would presume, and I do not have any factual knowledge on this, but of course because of, kidnapping and people moving children around the world without the consent of the other parents, the law most probably came and said, you know what, to avoid this type of abductions and with parents, acting, without the consent of the other parent, for example, the mother is taking the child out of the country without the father's consent, we require that for minor kids, both guardians' consent is required for an application for a passport. That puts basically a safeguard in place to avoid parents moving children out of jurisdictions without the other parents' consent. And then, of course, you can avoid the Hague Convention on International Child Abduction and so on by making it a bit more harder. But the end of the day is, the court is not much concerned about what parents want. The court considers what's in the minor child's best interest. So looking at the facts of the matter, clearly you have a strong case to go visit your mother overseas. The court order will obviously stipulate, that the child must be returned on a certain date. If you do not return the child by a certain date, of course, the Hague Convention kicks in, and the court that side can make an order that the child should be returned back to South Africa ASAP. Regarding the issue concerning high court fees can be very expensive. That's unfortunate. But if you are successful and you can motivate your case very well, the court may make an order that the father should pay those legal fees. Best would be to shop around, speak to various lawyers. You could possibly do it yourself if you have the necessary assistance to assist you with drafting your High Court application. The Children's Court, again, is free, but it depends on the Children's Court. I cannot for definite say, I don't know where specifically are. Some courts will say, no, go to the High Court. I've dealt with those type of matters in the past, where clients come to us and say, no, the Children's Court said you must go to the High Court. And I've also heard about matters previously where the client came to tell me, no, the Children's Court gave the father some time to consent, and if he doesn't consent, they'll make a decision. So there's a bit of a grey area regarding the Magistrates Court jurisdiction, specifically regarding stuff like relocation and passport and so on. Okay, question number 2, also from the Western Cape. Do you need to have a maintenance order to claim back pay child support? For instance, when the child was born, I never received anything. I never took the father to cause or had a maintenance order. 11 years later, can I claim for that back pay? Yes, you can. Of course you can. It's possible in terms of the Maintenance Act. I think it's Section 6 something. I speak under correction. You can claim. There is no maintenance order in place. You can claim birthing expenditure as well, the hospital expenses, and all expenditure which you have incurred for the minor child since birth until now. Of course, we have to consider the fact that you also had an obligation to maintain the child as well. So if you can work it out, I think it will be extremely difficult to work out 11 years, but if you can work it out and say, you know, on average, the child cost, for example, for the first year, 1,000 rand per month, I could afford 500. The father should have at least have paid 500 rand, so there you get your 500 times 12 is 6,000 rand for the first year. Then you move up. And then you get a big amount of money, and then the father must pay that because he had a legal obligation to maintain the child just as much as you had a legal obligation to maintain the child. So that is possible. Go to the maintenance court, but specifically advise him, I would like to claim that. The laying in expenses, the birthing expenditure, and maintenance up until now. Have a look at the Maintenance Act. It specifically deals with that, the type of orders the court can make. A maintenance court can make such an order that maintenance be paid since the birth of the child or since the time the parent has not paid maintenance, if there was no maintenance order. Very important, you may ask me that question. There was no maintenance order in place. That's what I'm dealing with. You can ask the court to make a order, a ruling that the sum of money since the child was born until now must be paid to you, despite there not being a maintenance order. I hope I made it clear enough. The third question from the Western Cape. Finally, last week we had a lot of questions on Gauteng, which I'm happy, and today we have a lot from the Western Cape, but one from Gauteng. Third question before I move on to the questions that are posed via Facebook Live. We'll do some housekeeping quickly, and I want to find out why am I not seeing those questions coming in. It's very weird. Nonetheless, let's move on. There's it. My child's father just had his fourth child and stopped paying maintenance completely. I know he earns a very small amount of money despite having more children and will use this as an excuse to have me pay for everything. If he's married with income into property, can funds be sought from his wife or parents? Okay. So I'm looking over here, looking at this issue. Parties are either separated or divorced, whatever the case may be, but he remarried. He has somebody, and they married income into property, and he's not paying maintenance at all after he had his fourth child. Okay, that's not right. You have an obligation to maintain all your minor children. No child has preference over the other child. That's very important to note. Of course, the reality comes in. If you do have another child, the first child or the previous child, of course, your contribution to that child will obviously be limited because you have an obligation to maintain a new child as well. And that mother also can take you to the maintenance court. And I doubt any maintenance court will stipulate, tell you, ma'am, you know that for the father had a child first from another wife, you have a child with him, unfortunately, you can't claim maintenance from the father. That won't work. Obviously, the court will have to work a fair amount of maintenance applicable. But regarding your question, may you claim maintenance from his wife? You cannot claim maintenance from his wife because she is not a parent of the minor child. She is a step-parent. However, because the father is married in community of property, he has access to the funds of the marriage, the community of property. So whatever maintenance must be paid should come from the joint estate because he has access to the joint estate. So indirectly, the wife can be held responsible towards the father's expenditure, being the maintenance for his previous children, which comes from the joint estate. So that is possible. I hope I answered your question where that is concerned. So the wife, his new wife, is not responsible, but the joint estate can be held responsible because he owns the joint estate. There is no separate estates. So if he gets 10,000, then he goes into the joint estate. If she gets 10,000, then he goes into the joint estate. If he gets into debt, the debt comes on the joint estate. And of course, maintenance is one of those debt. Thank you very much for those questions. I appreciate it. We are, of course, having a live Q&A again tomorrow, so you're welcome to pose whatever questions you may have using the links below. Okay, So, as I mentioned earlier on, while I was doing my webinar, there were a few questions posed via Facebook Live, and I could not deal with that, or didn't see it. Let's deal with it now. The first question. Good day, I am moving from the Western Cape to the Northern Cape. I have been working through the Hopefield Court for arrear maintenance, and there are 2 cases active, both criminal. One for the last year maintenance, where the father pleaded guilty and got a deferred sentence, but nothing happened to him. And a current case, which have been dragging on since April this year. The next court date is 2 December for plea. I suspect the father is going to plead not guilty to drag out the case. That would mean I have to travel here to Hopefield Court every time, 800 kilometers away. My question is, must I rather transfer my file to the Ark District Court and start all over again with the application for the maintenance? Or can I transfer the cases as is? Then the father has to travel there every time. The father now owes me over 200,000 in their maintenance. Okay, it's a difficult one because here we're dealing with criminal procedure, and the father has been subpoenaed to a Pacific Maintenance Court for committing a specific crime, and he committed that specific crime whilst the mother was living in that specific area jurisdiction. So if the mother leaves to a different province, I do not think the prosecutor would move the file to a different province because he committed a crime and it must be dealt with here. So if I steal your money and in Cape Town and you decide to move to Johannesburg, it doesn't mean the Johannesburg court can deal with the matter. So regarding the criminal case, and obviously speak to the prosecutor, the control prosecutor, senior prosecutor, that side, what would happen to your case? My guess is, and my informed guess at least, or reasonably informed guess would be that the criminal matter will remain in the Pacific Court where the crime got committed, or which had jurisdiction to deal with the matter at the time, despite you moving out of the court later. However, regarding the civil aspect, or your file, your maintenance file, or your application for increase, or whatever it is, that court can deal with your matter where you reside. So the court where you reside can deal with the matter. So if you move away from Hopefield to a different province, from Western Cape to the Northern Cape, your maintenance file, not the criminal case, the criminal case is the father's issue, but your maintenance file should go with you to where you are moving to. That I can tell you for certain. So if you live in Cape Town and you like to apply, and the maintenance court was in Cape Town, you granted your maintenance order in Cape Town, and you move to Johannesburg and you like maintenance in Johannesburg, for example, to deal with arrear maintenance, getting garnish orders, that specific file needs to go to Johannesburg court. The file follows you and where the child is. But obviously the criminal matter, because the father was charged here and is pleading here, he committed the crime here, that court will dispense with the matter accordingly. So I hope that answers the question, but still go to the public prosecutor. I gave my disclaimer on answering the criminal aspect of it. I'm not a prosecutor. Okay, question number 2. Morning advocate, my husband gets his kids only every fortnight, second weekend, and school holidays are split. That's just usually the standard, the reasonable contact aspect of it. Would like to apply for 50-50. The kids are happy to have that arrangement. Mom currently has primary residence. How do we go about applying for this? Okay, so I see it over here. So the stepmom is asking me the question. So her husband, of course, has contact every second weekend, but would like to have contact 50-50. The kids want it, and the mother's primary care. How do they go about doing that? So obviously they must sit on the table, the father, the mother, and everybody concerned, and they must say, can 50-50 work? Now 50-50 has various phases. One phase could be 1 week of the mom, 1 week of the dad. For example, the week starts the Sunday night, where one party drops a child that had contact, drops a child at the other parent's home, 6 o'clock the Sunday evening, and that the parent who exercises contact keeps the child the Monday morning, the Tuesday, right through till the next Sunday, late afternoon, whereby he gets into his car, takes the kids, I'm taking you now back to the other parent, and it goes on and on and on. For indefinitely, besides school holidays, where the parties will most probably share contact half-half. So half the school holidays and so on. Or it can mean 2 weeks, or 3 days, 4 days, 3 days, 4 days, depending upon the circumstances. It must be workable, it must be reasonable, and it must be in the minor child's best interest. Nothing sinister about it. It all depends on the circumstances. If the parents are living maybe close to each other, it most probably works. If the kids' parents are living far from each other, logistically it might not make sense. And it might not make sense for the kids, for example. Let's say the child, I'm using a Cape Town example, the child goes to a school in Cape Town, in the CBD. They have a nice flat in the CBD with a mother, and it's a 5-minute walk or 5-minute drive to the school. Perfectly fine. The father lives further out. He lives about an hour's drive from the school. That means for 1 week that the kids will be going to school, waking up, let's say half past 6 or 6 o'clock, with the mother, because they require about an hour to get ready and get to school. But with the dad, they have to wake up at 5:30 because they require an hour drive to get to school. So 50-50 might not work because of the school logistics. And it might affect the kids because now they spend an hour long in the morning, an hour long in the evening, driving to school and driving back. And it might affect the father's logistics. But it depends on the family. I honestly have no problem with any family doing anything that's workable, as long as the people are friendly with each other, amicable, amiable, they work together as a team. I have no problem with that. And the kids are fine with it and it works for the family. It depends on a lot of dynamics, the ages of the kids, affordability of the parents, and so on. So if the parties cannot agree, going back to our question, our Facebook question, if the parties cannot come to an agreement regarding 50-50 and how the dynamics will work, my suggestion is see a mediator, a family counselor, and try to assist you, unpacking this. Because sometimes people like the concept of 50-50, but they do not grasp what it entails. They do not grasp what it entails. How does it unpack? How will it unfold in the long run? Because the one daughter, she has extramural activities at school, after school, but now then the dad will have to collect the one child at 2 o'clock, go home, 1 hour drive, fly back another hour and collect the other child at 5 o'clock. It doesn't make logical sense, doesn't make pragmatical sense. Or they can work out a different scenario that's applicable to them. They'll know what's best for them. If the mediation does not work, then of course, if the father is adamant, he wants 50-50 and he believes it is in the minor child's best interest or the kid's best interest and it's workable and it will benefit them and do them well in life, then he needs to approach the court and the court will make a decision regarding that. So I hope that answers your specific question. This talking makes you thirsty. And the third question, the last question that was posed on Facebook Live yesterday. Good day, I'm looking. What happened there? Okay, let's move on. Good day, I'm looking for advice. My brother was in a car accident and we have a lawyer, but the lawyer gives us a curator. And they don't say how much my brother get. And my brother said he don't want a curator. They say my brother is not capable on with his money, the work. What can we do? Okay. It does fall under family law. Thank you for posing that question. Interesting question. Okay, so, and if I'm reading in between the lines, I do not know, but it seems to me like a road accident fund matter, whereby the brother was involved in a motor vehicle accident on a public road, and the lawyers got on board, assisted him with it, and they got some money. Let's say 100,000 rand for the accident. Now, the money can either be paid to the brother because he is, of course, the one that suffered damages. But the lawyers might feel, the brother is incapable of managing his own affairs because of whatever. There could have been a head injury and so on. And should they give the money to him, he will squander it. Then what happens under these circumstances? The lawyers will approach the High Court, and this is the High Court. This won't be the Children's Court or the Family Court or Divorce Court. They approach the High Court for the appointment of a curator ad litem, and that specific curator for litigation, that specific curator will do an investigation to determine whether or not the brother is in need or the brother is incapable of managing his own affairs. If the curator comes to that specific decision, the curator will obviously provide a report, and then that report will obviously be submitted with an application for the curator bonus, a third party to be appointed to manage the affairs of the brother. It could either be a family member or an attorney and so on. And then, once that has taken place, the court will make a decision whether or not to confirm that the brother cannot manage his own affairs and place the money with the